Chair.
Representatives Heisey, Horn,
Here, ma'am.
Damrow,
Here.
Muxlow, Jacobson, Patalia, Somerville,
Here.
Cotter,
Here.
Graves, Meadows,
Here.
Constant, Oaks, Brown, Irwin,
Here.
Kavanaugh,
Here.
Alumba. Mr. Chair, you have a quorum.
Thank you. We have a motion from Representative Horn to accept the minutes from our prior meeting. If there are no objections to the minutes, they will stand as presented. So be it. Ladies and gentlemen, we have just two administrative items on our agenda. Before we get to medical marijuana, we are simply, just so you understand, for those of you who may be new to the process, we have bills in our committee that don't belong in the committee. They were referred incorrectly. They have nothing to do with our subject matter today. We're just sending them to another committee. So if you'll permit me a few minutes to take care of that, then we can get on to the subject at hand. First, we have a motion from Representative Horn to re-refer House Bill 4866 to the Committee on Agriculture. Would the clerk please call the roll?
Chairman Walsh.
Aye.
Representatives Heisey, Horn,
Yes.
Damrow,
Yes.
Muxlow, Jacobson,
Yes.
Patalia,
Yes.
Somerville,
Yes.
Cotter,
Yes.
Graves, Meadows,
Yes.
Constant, Oaks, Brown, Irwin,
Yes.
Kavanaugh,
Yes.
Alumba. Mr. Chair, there are 10 yeas, 0 nays, and 0 passes. 4866 is reported with recommendation to the Committee on Agriculture.
Thank you. In addition, we have a motion from Vice Chair Meadows to re-refer House Bill 4864 to the Committee on Commerce. The clerk will call the roll.
Chairman Walsh.
Aye.
Representatives Heisey, Horn,
Yes.
Damrow,
Yes.
Muxlow, Jacobson,
Yes.
Patalia,
Yes.
Somerville,
Yes.
Cotter,
Yes.
Graves, Meadows,
Yes.
Constant, Oaks, Brown, Irwin,
Yes.
Kavanaugh,
Yes.
Alumba. Mr. Chair, there are 10 yeas, 0 nays, and 0 passes. 4864 is reported with recommendation to the Committee on Commerce.
Thank you. And the last re-referral is offered by Representative Horn. It's to re-refer House Bill 4865 to the Committee on Commerce. Would the clerk please call the roll?
Chairman Walsh.
Aye.
Representatives Heisey, Horn,
Yes.
Damrow,
Yes.
Muxlow, Jacobson,
Yes.
Patalia,
Yes.
Somerville,
Yes.
Cotter,
Yes.
Graves, Meadows,
Yes.
Constant, Oaks, Brown, Irwin,
Yes.
Kavanaugh,
Yes.
Alumba. Mr. Chair, there are 10 yeas, 0 nays, and 0 passes. 4865 is reported out with recommendation to refer to the Committee on Commerce.
Okay, thank you. Just a few overview comments before we begin hearing from people in our audience. First, we have added 30 more minutes to the meeting this morning. Some people have asked, why do we need to complete at 11:45? Just for those of you, again, who have not been to Lansing before, that's because the House convenes at noon for full voting session, and we need to be there for that purpose. So we'll adjourn at 11:45. However, I and the bulk of the committee will return to continue hearings after session if necessary. And I'll talk about that at the end. Right before, I'll remind people of what our intentions are. So I just wanted to lay that out for you all. We have 4 organizations that have yet to address us. They'll each have what I'm going to ask if they could keep it to 8 minutes, approximately, just a little shorter. You'll get 10 minutes like the others, but you could help us all out if you could address your subject quickly with questions from the committee. And then we'll be taking public testimony from people, and we'll be asking people to speak in 2-minute segments. Now, while we have 4 bills before us that are specific, my intention is we're going to try and hear you out and what your concerns are, and unless you get onto something that's completely unrelated to our subject matter, that's fine. If you're talking about a policy that's not before us, I'll rein you in a little bit. But if you're staying on the subject matter, we're all set, and we'll keep it to 2 minutes, and I think that way we'll be able to hear everybody that wishes to be part of this. And again, I would just like to reiterate, we've been working on this for about 9 months, and I and all of my colleagues have received several thousand emails collectively and visits from individuals. So this goes on, and we continue to take input. Last thing to note, we will not be voting today. We intend to take all the comments right through the adjournment today, even if we have to meet for 1 additional hour this afternoon, and then we'll work on the bills, and we'll notice you when the bills are up for a formal vote. So we're still in open testimony mode. Just wanted to make that perfectly clear. With that, we're going to go on to hear from the State Police. Sergeant Gill had joined us just at the end of our session. And Sergeant Gill, if you can join us again. Gentlemen, welcome.
Good morning, Mr. Chair.
You had given us a few thoughts and just opened to questions. Is there anything you want to add today, or should we continue with questions that still may exist from committee members?
I think we had pretty much answered everything that a lot of the questions that you initially had. I don't really have anything to add other than just to take some questions from the representatives if you had any other concerns about the registry and access to the registry, that type of stuff.
Okay, very good. And Sergeant Gill, and I apologize.
Lieutenant Gill right here.
Lieutenant Gill, that's right, because you're not related. But
as the Sergeant, Detective First Lieutenant Tim Gill with Michigan State Police, and I'm the commander of the Drug Task Force section out of the 1st District, and we are not related, as he said last time.
Well, thank you again, Lieutenant Gill. I appreciate that.
Thank you.
Are there any additional questions for the Michigan State Police? Representative Horn?
Thank you, and thank you for your testimony last week. And one of the thoughts that we had over the course of the last week in terms of the usable product, the usable medical marijuana, from your position heading the drug task force, what is the position of the Michigan State Police on usable product? And I'm talking about not just the smokable product, the medibles, the ointments. How do you measure what a usable product is?
Thank you for your question. Well, that is a difficult thing. I don't believe that the state police has taken a position as neutral on any issue related to that. However, it does change. This definition does change what has historically been the definition of marijuana in the public health code. So it does create some different challenges. When you say usable, most marijuana does not get sold or exchanged, and where it's been completely processed and is devoid of seeds and other things that are in the definition of usable marijuana. So that does pose some challenges, not only for the police but for the courts. And to be able to go through and weed out, if you will, all those items, the stalks and the seeds from that product is not something that's easily done, or something that we probably want our officers doing. Thank you.
Representative Kavanaugh?
Thank you. And I appreciate your help during this process. But I'd just like to know from a general law enforcement perspective, has your perspective or the way you treat marijuana changed since the enactment of this law? And my second question would be, is there anything we can do that would be helpful to law enforcement to differentiate between medical marijuana plants or patients and the broader scheme of, drug dealers and the people bringing it in by the pounds or the tons? So your perspective on this, as far as enforcement currently, and if there's anything this committee can do prospectively.
Well, the changes that we've had to initiate is when you get information about somebody trafficking or possessing large quantities of marijuana, you have to try to figure out whether or not they hold a caregiver card or a patient card. And that's difficult to do, as you know from all the discussion that's taking place around the current law. We have instances where we've encountered marijuana and found that the people were in compliance with the rules of it with respect to their patient card or their caregiver card. But in many more instances, we found that people are not in compliance, are growing well in excess of the limits that they have under the Act. And in fact, our marijuana seizures have actually increased in the last year because of it. As far as helping law enforcement, again, access to the registry in an easier fashion, but still protects those rights that many folks have expressed concern about, I think would be in order. And then cleaning up some of these areas, the photo ID card, issues regarding dispensaries, those kind of things would be helpful to us as law enforcement officers.
Thank you, Mr. Chair.
Thank you.
Are there any, excuse me, any additional questions for Representative Damrow?
Just to clarify one of the questions we had last week and some questions I've had in my office in speaking here with our work group members is when you make a lien request, a police officer makes a request through lien, the information that comes back, even though a person is registered with a medical marijuana card that is on the lien system, somehow it's identified there, just by making your request through lien, the response back from the lien operator or the dispatcher is not something that states, by the way, this person also has a medical marijuana card. Doesn't that have to specifically be requested by law enforcement?
Yes, it does. In fact, you have to actually have the card or the card number in hand. The difficulty that we have is many times, as we're investigating cases, you don't know whether they have a card or not, and there's no means to check currently, short of going and talking with that person or having them right in hand where you can look at their card. If you call in the card number, the only information you'll get back is whether the card is valid. You won't even get back information as to who the card is registered to. And that poses challenges as you're investigating these cases. If you get a tip, if somebody's got a card and we knew that up front and the tip said, you know, I see the guy's or lady is growing 5, 6, 10 plants, well, if we know they've got a card, we're probably not even going to bother with that because, you know, with that kind of a tip, you know that they're in compliance.
I think some of the confusion was, so if they pull you over, if you get pulled over by law enforcement, you've got a broken tail light, and they call in your license plate, that it's not going to come back, you know, once and warrants, and oh, by the way, they also have registered for medical marijuana. It has to be specifically requested. And that's where there was a lot of confusion with people that they're saying, well, all they have to do is do a lien check, and all this information comes flowing to every law enforcement officer or any law enforcement officer listening on the radio. So
you are correct, and that's not the case.
Thank you for the clarification, because that's been a number of phone calls and discussions in our office that this information was always shared every time. Thank you, Mr. Chair.
Thank you, gentlemen. Representative Irwin?
Thank you, Mr. Chairman. I'm interested in the issue specifically of the enclosed lock facility. We have a bill in front of us here that seeks to clarify that, really sort of heighten the level of restrictions around what exactly is an enclosed lock facility. I'm curious as to what the state police's interest might be in that. What is the potential public safety hazard with marijuana being cultivated, and you know, what would be the state police's primary interest in trying to address that public safety hazard? How do you see it? What's the problem that we're trying to address here?
I think you're trying to address the problems related to the rules surrounding the Act. I'm not sure that I understand your question.
If I may clarify, what I'm trying to understand is that you know, we write these laws, I would think, to promote public safety. Right? We're trying to promote public safety with these laws. So what is the potential public safety hazard of marijuana cultivation? Because I think what the point I'm trying to make with my question, I suppose, is that you know, our regulations and our laws should be as closely hewn as possible to the public safety hazard that we're trying to address. So what is the potential harm to the public of marijuana being cultivated? Is it fires? Is it the potential that someone's lights may cause some type of fire hazard? Is it that you're afraid people are going to come along and see the marijuana growing and then go after it in a way that might cause them to illegally obtain it or violence to occur? What are you worried about?
Gentlemen, just you're welcome to respond as you wish, but I would also direct Representative Irwin to the bill sponsors directly, and either Kavanaugh or DeHorn. But if you're comfortable, you didn't draft the laws, but
Right,
if
no,
you're
I
comfortable, you're welcome to adjust this.
Well, just for a point of clarification, sir, are you talking about, like on the House Bill 4856, where it says enclosed in the case carried in the trunk of a vehicle, like the transportation aspect, or are you just talking about, because of the Act, it says that it must be in an enclosed locked facility pursuant to the Act?
Yeah, I'm actually interested. I'm interested in the transportation issue as well, but I was really talking more about the cultivation issue, because we've got a court case. I think it's the King case that's going forward to the Supreme Court now. You know, I think what we're talking about here is, does the enclosed and locked facility have to be of specific specifications? Are we going to put it into the Act that there have to be 6 walls on this facility, or could it be outdoors in certain cases if we address the potential public safety harms of that we're trying to address for our citizens?
Sergeant Chris Hawkins with the Michigan State Police. Sorry, I arrived a little bit late. The definition that I think we're going to add in this bill was reached as a result of a work group with many stakeholders. As far as the MSP's interest goes, I guess my assumption in what the public safety benefit is of having it in an enclosed locked facility would be making sure no one has access to the marijuana that shouldn't. Could you have an enclosed locked facility that is outdoors that adequately protects people from accessing it who shouldn't? I think you probably could. The Michigan State Police's interest is in clarity. We want to make sure whatever definition we have for how this marijuana should be stored is very clear and we can easily enforce it. That was the definition that was arrived. That was the definition that was arrived at through the work groups. It's clear, it's easily enforced, and that's the limit of our input. Whether or not there's a public safety benefit to requiring the enclosed locked facility to be enclosed on all 6 sides, or whether it could be outside, that's a public policy decision that fortunately we get to pass off to you legislators, and you get to make that decision. What we would ask for is whatever you ultimately come up with, that it is very clear and easily enforceable, so we will know whether something meets the definition of enclosed locked facility or not when we see it.
Thank you.
Hope that helps.
Thank you. Representative Horn?
Just to that point, Mr. Chairman, for clarification, the Michigan State Police never asked us to clarify this. They're willing to enforce any law that we write. Currently, in the Medical Marijuana Act, there is a definition of enclosed locked facility that's being interpreted differently by the courts. The courts are asking for clarity, and so without some clarity on the legislative through the legislative process, the courts will continue, to make their interpretations. And so basically, we're codifying what they're saying, or we're informing the courts with this language.
Thank you for joining us again this morning. Is there a representative in the audience that wished to speak? We had a card turned in last week, but not a name. The Medical Marijuana Group's National Patients' Rights American Medical.
We have the National Patient Rights Association.
Does that sound close enough? Is it it? Association? All right. Why don't you step up? That's got to be it. Sorry that we didn't have your correct name down. And if you
Jeopardy, that passes.
that was close enough. If you could please identify yourselves, I'd appreciate it.
Absolutely. Robert Mullen, spokesperson for the National Patient Rights Association.
Thank you.
Typically, I don't need a microphone, but I'll tone it down a little bit today. Appreciate the opportunity, committee, to speak in front of you. I've never been in front of a legislative body, so I'm probably not overly familiar with your procedures. I have looked at the 4 House bills that are in front of you, and I want to kind of keep my comments directed just to that, even though I probably have a lot more to say on the issue. First off, our organization is a grassroots organization, and the primary focus is to have safe and consistent regulations. I think clarity helps everyone, but in reaching clarity, we want to make sure that we have reasonable regulations to the Act. The first act, House bill that relates to the registration ID cards, I'd like to address. I think that's a good idea. We support it. Photo identifications, I think, are good. It gives out information. It helps identify the caregiver and the patients. Having a 2-year registration, I think, is also a good idea because it lengthens the time period before expiration of the patient's card. The questions or the issues that I have are more related to allowing police access to registry based on just a reasonable suspicion standard, as was denoted in the House bill. And let me explain why I have that position. I'm a little concerned. First off, we're dealing with a privacy issue regarding someone's health care. This is medical marijuana, and these are health conditions that we're talking about, and so we need to have a little more scrutiny when we're dealing with someone's private health issues. And the problem is this: if we're going to have an honest conversation about medical marijuana in general, we have to look at the issue of the contentious relationship that there's been between police and the medical marijuana community. There's a lot of different forces that are in play here, and I think the better suggestion would be to have it be a probable cause standard. Why do I believe that? At a probable cause standard, we're talking about the issuance of a warrant or an arrest, and it makes sense at that point to allow law enforcement access to the registry because it might avoid wasting resources and kicking people's doors down. It might avoid wasting resources and manpower of doing these raids, and they can be dangerous. We know that. And furthermore, if the issue is rose to the level to where there's probable cause, I think it's in the patient's best interest to have law enforcement be exposed to the registry because it could avoid them a lot of problems. Now, when I talk about this contentious relationship, there's a lot of things going on here. Law enforcement, to some degree, has a profit incentive in the drug war. I mean, this is not my words. The facts of the issue will back up everything I'm going to tell you. It is a multi-million-dollar industry in the state of Michigan. It is a multi-billion-dollar industry nationally. And what happens is when you have large sums of money involved in this interplay, it politicizes the issue. And, you know, to briefly touch on this issue and why it's so important and how we look at the relationship between law enforcement and medical marijuana, we have to realize that all forfeiture funds are unearmarked. Policing agencies can use them for whatever thing they want to use them for. There's very little oversight or regulation to these funds. It creates a huge incentive to want to go after these funds. So therefore, it ramps up some of the enforcement that goes into the drug war. Additionally, what happens is law enforcement has other significant tools in dealing with coming to determinations whether or not someone's a medical marijuana user or a patient. They have surveillance, confidential informants. Often confidential informants are the sources of where warrants and investigations start. If we have good quality policing, they're going to know a lot more about the subjects than just having to go on a registry and figure it out. So when you look at this issue, I want you to kind of look at some of the interplay that's going on between the two different groups, realize there has been a contentious past, and take that into consideration. As I've indicated, I think a probable cause standard is probably in the best interest of everyone. Law enforcement should have access to the registry, but in a very limited sense, or in a very limited manner. Regarding physician-patient relationship and a bona fide physician-patient relationship, first I'd like to say that the state of Michigan, through case law, has established what a bona fide physician-patient relationship is. There's a plethora of Court of Opinions and Court of Appeals opinions and other decisions that kind of outline what the law is in this area. Unfortunately, as it applies to medical marijuana, it's kind of not been taken into consideration, and we do have a broken system regarding the physician-patient relationship right now because we have what I consider an unqualified arbitrator, the judiciary, deciding on a case-by-case basis what is a bona fide physician-patient relationship. So the organization welcomes defining the physician-patient relationship. I think it would help physicians. I think that having a good recommendation process is at the foundation of having a legitimate medical marijuana system. So I think it's in everyone's best interest. Now, I will mention that there are some issues with the proposed bill, and one of them is related to I want to make sure I get this right, House Bill 4851, Section A2, where it indicates that one of the conditions is that the physician has to see the patient for something other than what the condition is that they're applying for the medical marijuana registry card. Well, that's a little bit problematic, and I'll tell you why. Because a lot of physicians won't write medical marijuana recommendations, and there can be a whole host of reasons why, whether it be political, maybe they don't believe in the treatment. So some physicians have taken the position of specializing in medical marijuana recommendations and actually truly believe in the therapeutic benefits. So by outlining in this act, this House bill, that you must see the person for something outside of the medical marijuana condition and be treating that person in addition to that, I don't think is being fair in looking at the current state of this interplay. I'll give you an example. If you're a patient and you have a UA doctor, you go to a VA doctor. Well, VA doctors are prohibited by law from making medical marijuana recommendations. So if that was your primary care physician, you would have to go to a different physician in order to get a medical marijuana recommendation, because even if that VA hospital believed in medical marijuana as a treatment, they'd be prohibited by law from issuing a recommendation. So you have to look at the issue as how this interplay between physicians and patients, and realize some doctors are 100% for it, some doctors aren't. Some doctors are prohibited by their employment status. And so for that reason, I think that that particular standard, that issue in the bill should be looked at again. And, you know, the other question I have is, are we creating a circumstance where we're adding additional requirements on the doctor in order to make this recommendation? Or should the recommendation be, the bona fide physician-patient relationship, be similar to what's required to prescribe other treatments? And, excuse me, I'm going to ask for my water here. The other thing that I would like to mention is this. If you look at the Medical Marijuana Act, there is a provision in the Medical Marijuana Act that provides for health organizations and regulatory organizations to regulate doctors. And the Medical Marijuana Act, under Section 4F, at the bottom of the paragraph it says, and I'm reading right from the Act, provided that nothing shall prevent the Professional Licensing Board from sanctioning a physician for failing to properly evaluate a patient's medical condition or otherwise violating the standard of care for evaluating medical conditions. It's right there in the Act. And unfortunately, that's been overlooked. I think to some degree the healthcare community has to step up and do their job. We realize there's a huge disparity between what is required to get a medical marijuana certificate and recommendation. I clearly think that non-person interviews and non-person examinations are unacceptable, and there should be a much higher standard for that. Regarding transportation, I think that transportation regulations are not a bad thing. I don't think medical marijuana use and motor vehicles have anything in common. I think that a motor vehicle should be only used, and the organization feels that a vehicle should only be used for the transportation. So if there is some type of regulations that will allow a safer transportation and that is more responsible, we're 100% for it. I mean, yes, it would encumber people to have to be a little more careful, but so what? This is, you know, we want good regulations, and we want this to be, you know, something that both law enforcement has an expectation of what it is, and the patient knows what their obligations and duties are as well. And the final thing that I'm going to mention is regarding adding an additional sentencing guideline for violation of selling to someone outside of the registry. I really don't think it's necessary. The organization doesn't. And the reason we don't is because if you violate the Medical Marijuana Act and you sell marijuana outside of the registry, you've committed a felony in the state of Michigan. At a minimum, it would be a 4-year felony, a Class F category of a felony, and depending on the weight and the amount, it would go up from there. The proposal is to make the 2-year felony a Class G under the sentencing guidelines, and without going into all the details of the interplay of how these guidelines would be interrelated, let's suffice it to say that under the way it currently is, and even if you changed it to give it a higher, to give it a sentencing guidelines, it's not going to change what the ultimate punishment is. If somebody was charged with the 2-year felony outside of selling outside of the registry, and additionally were charged with the 4-year felony of manufacturing or delivery, the 2-year felony would only serve as an enhancement for points on that, and the G grid that you're proposing wouldn't even come into play. They wouldn't even use it. It's the lower grid and the lower of the charges.
All right, thank you. You made your 10 minutes, and I appreciate that very much.
I tried to.
And I realized how I botched your names. We had 2 names drafted right in together, and so I apologize again for not having that correct. Do we have questions? Mr. Horn? Representative Horn.
Thank you, Mr. Chairman. Going back to the bona fide physician-patient relationship, in House Bill 4851, the draft 3 copy, can you point to me where your concern is? I didn't quite understand what you were getting at, because we've created because of the act itself says bona fide physician but doesn't describe it, and I know later on it talks about not sanctioning doctors, but the hospital groups and doctors groups are telling their doctors how they're going to behave in this arena, right? Which is causing a big problem. But under this section 3 in House Bill, or on the first page of that, do you have a copy of that most recent?
I have Section 3 as using this act. I have the first page. I don't know if I have the right bill.
Yeah, perhaps not. I was just curious. Maybe that's the case. Thank you, Mr. Chairman.
All right, thanks. Representative Kavanaugh?
Specifically, the point of a doctor having to see the patient or being barred from seeing the patient for must see something other than a medical marijuana certificate. As we proceeded with testimony, we struck that language. So I believe in the amended bill, it is taken care of. But my point is, you said a probable cause standard would be much more beneficial. Can we put a probable cause standard on the officer, or are you saying that they must have a warrant before they can hit the registry?
I say a probable cause standard, because a probable cause standard would allow them to get a warrant and would allow them to effectuate an arrest.
But absent taking that additional step, they could, as long as they could articulate a probable cause, they could check the registry.
Correct.
Fair enough. Thank you.
Representative Graves? And by the way, welcome to our newest member of the Judiciary Committee. Representative Graves won a special election only 2 weeks ago. Welcome to Judiciary.
Thank you, everyone, and thank you, Mr. Chair, for this opportunity. You mentioned the VA healthcare. I'm blessed enough to have VA healthcare, and I don't use VA healthcare for everything. So I think that's probably true with most veterans. With this law, I think you would still be able to see a physician of your choice for any particular issues outside of what the VA would normally treat. Do you disagree with that comment?
Well, Representative Graves, I think that you're correct in theory, but it becomes a cost factor. There's a lot of people that go to the VA for all their health care needs because economically they have no other source of insurance. And there's a large number of uninsured veterans, and so they're totally dependent on the VA. I would agree that if you're a patient of the VA, you're not prohibited from seeing anyone, but then the prohibition becomes cost prohibitive. And in cases that I've seen and people that I've dealt with, the VA is their primary caregiver for all their needs. So the option of going to a private physician is available, but it's cost prohibitive.
Well, I think it's probably true with most of it. You know, I pay for any additional medical expenses as well that's not treated by VA. So, thank you.
Sir.
Representative Horn?
Just as a matter of clarification, Mr. Chairman, we discussed this briefly last week too. The VA hospital is a federal government hospital. And this, and marijuana is not medical marijuana in the eyes of the federal government. It's what we're trying to protect patients from. And so a doctor at the VA hospital would not be recommending medical marijuana, so you have to go to another physician. They have no choice. They can't violate federal law. So I just want to make that clear as well. And that's a problem that we've been having, in other hospital groups and with doctor groups.
Thank you. And thank you for joining us today.
Thank you, sir.
Representative Damrow?
Not a question, but just something for clarification, is talking to a lot of the veterans, is that you can get copies of your documents when you do have extensive medical work done at a VA hospital, and you can't afford to have that done someplace else with a private physician. You can get copies of your VA documents, medical records, and take them and save an extensive amount of the cost by going to a private physician and using those documents and not duplicating all the extensive and expensive tests. Thank you, Mr. Chair. Okay.
Thank you, and thank you for joining us.
Thank you.
Our next group is the American Medical Marijuana Association. Do we have a representative of the MAM? If you could join us, please. And if you could please give us your name. I did not see a card in, so if you could just give us your name, I appreciate it for the record.
Yes, sir. My name is Jay Van Dyke. I'm the executive director of the AMMA.
Please sit down so we can hear.
Thank you. Known as the American Medicinal Marijuana Association, not medical.
Oh, thank you.
You're welcome. The MMA and we the people would like to address this Honorable Judiciary Committee with our mutual and great concern for public safety, but also law enforcement personnel safety issues with medical marijuana in this great state of Michigan. Our main primary focus and objective of the MMA with our suggestions to this committee is to save lives and get medical marijuana off the streets and out of reach of our highly impressionable, peer-pressured, and experimental young teenage society. The MMA also advocates our personal right to choose what medications we the people choose to put into our bodies, which doesn't cause death and a host of other side effects many medications bring along as partners. Our law enforcement officials have lost many friends in the line of duty from our drug war in this brave and admirable crusade without, however, to slow down our astronomical and pandemic proportional public safety problems to save the people from ourselves. With regard to House Bill 4834, photo requirement on medical marijuana cards, many people thought medical marijuana cards would be made from our Secretary of State driver's license department. I personally think that particular department does a fantastic job of issuing millions of driver's licenses per year with all due diligence in a couple of weeks. I would like to add our driver's licenses look very attractive and professional, and they are accepted forms of identification by many banks and other businesses. It has taken 4 and up to 8 months for many medical marijuana registry identification card holders to obtain the physical card, which is not as attractive as our privileged Michigan driver's licenses. Many police officers thought the original cards were phonies because of the ultra-simplistic design on a white piece of plastic. My question is how much does it cost the state of Michigan to process driver's licenses, which cost citizens less than a medical marijuana state registry identification card? If the cost is reasonable, why couldn't our driver's license printing department print medical marijuana cards as well? Law enforcement officials could then recognize the state of Michigan's usual professionalism and demeanor in a similar license design and with photograph within a 2-week period. Many people thought that that was the intent of the state, to issue homemade-looking phony cards to justify arrests of medical marijuana patients and caregivers, seizing medication, money, and detainment of patients and caregivers. Please understand that our suggestion for the printing department to print state registry identification cards only and not to distribute that medical information to any other agency or national database. Printing only. House Bill number 4851, the clarification of the bona fide doctor-patient relationship under the House Bill 5408, which states in Section 1, which was recently passed concerning the telemedicine diagnoses, care, and education with their patients. And that section applied to their certificate that was issued or renewed, and this law is effective July 2012. However, there was a state-issued memorandum sent out to the medical doctors involved in Michigan medical marijuana doctor recommendations for the medical marijuana cards, addressing the bona fide doctor-patient relationship and a pre-existing relationship specification, which has not been issued for any other medical prescription protocol except medical marijuana. The directive is unreasonable and discriminative by nature and implicitly designed to scare and subject physicians to disciplinary action within their medical licensure and career, paying off their student loans. The memorandum directive targeted medical marijuana patients specifically due to our economy. Many of our Michigan citizens have not been to the doctor in years and have been actively using marijuana for their pain illegally for many years. The people do not need a pre-existing relationship when they go to the doctor to obtain any other medication with a current health problem. Only marijuana recommending physicians were targeted. Additionally, the memorandum also stated that the Internet telecommunications was not a face-to-face physical examination when a law is being passed accepting telemedicine for nonprofits and other healthcare providers. The military has been using telemedicine in the battlefields for close to 30 years, and they perform brain surgery via Internet telemedicine. All medical doctors do not possess the same degree of knowledge and at times confer with other doctors with more experience in a particular medical situation. When the Michigan Medical Marijuana Act was approved by the majority of voters in 2008, a few citizens and doctors knew about the new law. Only a few knew about it, and as a result of having experience in other states, several out-of-state doctors came to Michigan and advertised certifications were available to qualified debilitated and chronic pain patients could, under law, possess and cultivate medical marijuana for medicinal purposes. Many Michigan doctors with normal medical practices did not know of the new law, and they do not possess any knowledge of medical marijuana, and as a result, very few Michigan medical doctors did medical marijuana patient recommendations, and the business went to out-of-state clinics who had the previous experience and knowledge of medical marijuana, and they advertised. We talk to people every day who didn't know, and they still can't believe that there is a Michigan Medical Marijuana Act. I believe all the people in the audience here today will attest that when they first learned about the Michigan Medical Marijuana Act, they didn't know what to do or how to go about it. It is interesting when patients learn about Michigan medical marijuana, they don't know where to go to get certified or obtain medication. And I think the audience will also agree that they were afraid, timid, and shy about asking a clinic about medical marijuana. We get unavailable caller IDs all the time because the people just can't seem to wrap their brain around the fact that we, the people, made all this possible from 80-some years of prohibition. House Bill 4853, Criminal Procedure and Sentencing Guidelines for Providing Medical Marijuana to Unprescribed Users. The same criminal laws should apply to the public, patients, and caregivers. House Bill 4856, Transportation of Medical Marijuana in a Motor Vehicle. The MMA has issued member policy regarding transporting medication in the trunk of their vehicle or in a locked container inaccessible inside a vehicle without a trunk. Medical marijuana, public nuisance issues, and the lure to danger is the #1 problem confronting law enforcement and the public in Michigan and in the other 15 legal medical marijuana states as well. Our law enforcement personnel and our citizens pay the ultimate price equally in the muggings, carjackings, and deaths generated from medical marijuana incidents and crimes initiated by the public, young and old, attempting to obtain medical marijuana in a public place illegally. The MMA is about our basic God-given and constitutional right to life and our right to choose our own medication, which does not cause death. We, the people, should have that right to choose what we put into our body. How many celebrities do we have to lose before we, as a people, understand all the death-defying dangers associated with using prescription medication in a manner that is otherwise directed on the label and or by a physician, and as demonstrated by so many people, can cause death with long-term use? Why do these people get addicted to these self-proclaimed highly addictive pain medications that can cause death with long-term use, which can and does cause kidney and liver health problems? We put our faith, hope, and trust in our doctor, and yet doctors are prescribing pills that kill. So much for our standard of care issue here. So why do these people, celebrities from Elvis to Whitney, and us, we the people, us common folk, misinterpret, not comprehend, not read or pay attention to the warning labels or take one alcoholic beverage and become comatose? Why do we play doctor, attempting to make ourselves feel good? That is the $64 million question. Pain, we live in a painful environment, and we carry our pain silently because no one wants to hear it except the doctor. I think everyone here today thoroughly understands you can't judge a book by its cover, and I think we can all agree we can't feel each other's pain or comprehend the exact degree of a patient's threshold of pain. We go to the doctor that has a standard of care to do no harm. And we the people, us common folk, if we use that type of medication in a manner that is otherwise directed, can cause death if we read it and are intelligent enough to understand, comprehend all the complexities involved in a doctor's PDF book. Try to judge that book by its cover. After 80 years of marijuana prohibition, now comes us common folk, we the people, in a majority rule vote, asking this honorable Judiciary Committee to grant us our liberty and enact a fair and reasonable law to protect the public safety issues and protect the people from ourselves. The complexities of medical marijuana and the public nuisance issues are many. This has proven to be a very difficult and arduous task for the great state of Michigan. The MMA has innovated viable and workable business solutions to enact a medical marijuana law that is in the interest and concern for public safety and not be a public nuisance. The MMA humbly presents to this honorable Judiciary Committee zoned medical facilities or offices to certify and 2, dispense cannabis medication, 3, to educate and enforce members not to be a public nuisance, 4, no public signs, banners, or advertising to specify medical marijuana is available here. Discretion has always been a better part of valor. The MMA has a business model to make medical marijuana medical. In our approach to a safe and appropriate enclosed locked facility with safeguards of policy restraining the public free-for-all mentality that has permeated and saturated our voting public's misinformation and ambiguity that all the king's horses and all the king's men are grappling with an issue that they are not infinitely familiar.
Mr. Van Dyke, if you could wrap up in about 10 or 15 seconds, you're at 10 minutes.
Thank you very much. I think that's...
You went pretty well along. I was watching you go through your document. Are there any questions for Mr. Van Dyke? Thank you, sir. I appreciate your testimony.
Very much.
Our next group, we will have a presentation from members of the Michigan State Medical Society, Colin Ford, and just Colin, right? Yeah. Welcome.
Thank you. My name is Colin Ford. I'm the Director of State and Federal Government Relations for the Michigan State Medical Society. Before getting started, I just want to thank the Chairman for the opportunity to speak, but I'd also like to single out Representatives Horn and Kavanaugh for the work that they've done reaching out to the medical community to work on this issue. My comments are limited specifically to House Bill 4851, and within that bill, our interest is limited to the portions dealing with the bona fide physician-patient relationship. We believe that is necessary largely due to the inclusion of Section 4F in the Medical Marijuana Act, which was discussed earlier. That's where the bona fide physician-patient relationship. There is the secondary clause in that section that does state that provided that nothing shall prevent a professional licensing board from sanctioning a physician for failing to properly evaluate a patient's medical condition or otherwise violating the standard of care for evaluating medical conditions. So even though that sounds like that provides the licensing board with the authority to move forward with a sanction if that's appropriate because the physician didn't meet the standard of care, it's only limited to the evaluation portion of the visit. And the evaluation is the beginning, so to speak, and then there's also the treatment aspects, the follow-up. The standard of care is actually much more broad than just the initial evaluation. And in the instance of a card for medical marijuana, you're potentially giving a patient 1 year's worth of access to marijuana or cannabis or whatever term you want to use without any sort of need for follow-up care on the part of the physician. So in speaking with the regulators, in speaking with some of our members, seeing some of the things happening in their communities, that was not sufficient to allow some of the people that they felt were unscrupulous providing medical marijuana certifications without doing a sufficient workup on the patient. And so that was the beginning of our interest in pursuing language to define a bona fide physician-patient relationship. because when you take into account the balance of that section of the law, bona fide physician-patient relationship really truly becomes the aspect that the regulators have to regulate the profession of medicine. The Board of Medicine is the body that does regulate the profession of medicine for physicians. There's also an osteopathic board. This would apply to both. So we think that that's a very reasonable approach, and we have appreciated the opportunity to weigh in on the precise language. Some of the questions that have been asked is why wouldn't we address this in the Public Health Code? The Public Health Code, because of the way that the Board of Medicine interacts with physicians, there is not a need to have a definition of bona fide physician relationship. That authority is already granted to regulate the profession broadly under the Public Health Code for any other drug, any other substance, any other treatment. And so it's not necessary more broadly than for this specific treatment. So I don't want to get into too great a detail. That's really our major concerns with the lack of certainty that the ballot proposal provided for physicians and our ability to self-regulate. And so we've appreciated, again, this opportunity to present today, but then also to participate in the shaping of this legislation.
Thank you. Representative Brown.
Thank you, Mr. Chair. And thank you for your testimony, Colin. And you touched on my question, but I guess now I'm even a little more confused. And that my question was going to be, would you support putting the definition of bona fide physician-patient relationship in the health code? And I guess now you're saying there's not a need for it, so I'm not clear as to why there's a need for it in this act then, and why wouldn't it be covered under the same?
Because in Section 4F, it basically strips the authority of the Board of Medicine to regulate physicians who certify patients for medical marijuana. It takes that authority away, and then it adds back a section that says that as long as there is an ability of the Board of Medicine to sanction someone if they don't meet the standard of care for the evaluation of the patient. But in our opinion, that's not broad enough, because the treatment of the patient begins with the evaluation. It doesn't end there, though. There's some ongoing treatment. If this were any other substance or any other treatment, or the Public Health Code already provides, there's no preclusion anywhere else for other types of procedures that the Board of Medicine can't regulate. So we don't feel that there's a need for that to be included in the Public Health Code. The Medical Marijuana Act references bona fide physician-patient relationship, and it also creates the different standard of regulation for physicians.
Okay. All right. Thank you.
Representative Heisey, and then Irwin.
Thank you. I got a question about the Board of Medicine, the Board of Osteopathic Medicine. These are the two state-sanctioned or state-created regulatory bodies that, in your opinion, would have the ability to determine the bona fide physician-patient relationship? How does that work?
I'm more familiar with the medical board. The osteopathic board, I believe, behaves very similarly, but it's 10 physicians, 9 public members, and they make determinations about the appropriateness of care or behavior of the profession of medicine. I guess the closest example would be it's basically the state bar,
right?
But in our situation, the state actually operates it. It's not a not-for-profit entity. So,
okay. Well, then, do you believe that this would result in a plethora of appeals or hearings that this board would have to undertake as a quasi-judicial body?
I don't think that it would. I think that it would I think that it would create more clarity within the profession of what standards need to be met. But I don't think that it would necessarily. I don't think it would necessarily trigger. I think most physicians that are in this position are doing these things anyways. I mean, this is a pretty reasonable set of requests to make.
Are they? Is the Board of Medicine a rule-making body, or do they make a rule based on a petition or a particular fact pattern that is brought to them?
They generally don't they can help originate rules, but they don't do that very frequently. I mean, that's not some. They're largely a disciplinary. Their function is largely disciplinary for the most part. So they take in allegations and then they make findings based on a specific allegation of an individual and their conduct.
And I would assume that those that the aggrieved party could appeal those decisions, correct?
Absolutely. I mean, there's various levels of. You should invite Ray Ramsdell. She's actually really she's the director of Bureau of Health Professions, and she could speak to this better than I. But there is an initial review by the Bureau of Health Professions, and then it moves through the process. And ultimately, if there's a finding that the allegation has merit, then it goes to the full. Well, it goes to a subcommittee of the Board of Medicine, and then the full Board of Medicine, as I said, 10 physicians, 9 public members, ultimately makes the finding.
Okay, and I with the indulgence of the chair, then.
Last question. We have other questions and a lot of people that wish to testify.
Because that is a state body, though, unlike the state bar, then is their final decision final and binding, or is there an appeal route?
You can then appeal, and he's actually handled some of the cases. But there's judicial. You can request.
So it can end up in court anyway?
Yes.
Okay.
Representative Irwin?
Yes, and I'll try to be really brief. Has the Board of Medicine taken up any cases, any disciplinary actions around doctors who've been accused of abusing their authority under this Act?
I'm probably not the right person to ask. I have heard of one case, and it was based on, again, a portion of Section 4F that allows some discretion on the part of the board, and it dealt with a physician who was not properly taking a physical history and exam of the patient. Another thing that specified that if that standard's not met, then that can be a violation of the Medical Marijuana Act as well. So that's one case that I've heard, but again, you'd be better off speaking to the regulators directly.
So it sounds like the process of complaints and consideration of those complaints is working, and that the Board of Medicine has an opportunity to sanction doctors that are acting inappropriately. So, I mean, that would be my perspective. But just a real quick follow-up question is, I've been talking to a few doctors in my district about this, and the one question I continue to put to them is the same question I'll put to you. And I've gotten the same consistent answer from all of them, which is there any other area of the practice of medicine, is there any other area where doctors are recommending medicines or recommending treatments or recommending prescriptions where the medical society would have the legislature come in and stipulate what type of relationship doctors can have with their patients?
Well, again, I don't think that that's what we're asking for here. I mean, the answer to your question is that's not been an issue before, because it's never that responsibility to regulate the profession has always been left to the Board of Medicine, and this is the first time that we've encountered a specific drug, substance, what have you, that has weakened the ability of the Board of Medicine to self-regulate the profession. And so, you know, I don't know if that's necessarily a fair question to ask without giving sort of a broader answer, so I apologize if I didn't answer your question directly. So,
thank you.
Mr. Ford, thank you for joining us this morning. I appreciate it. We have a last group from the Eaton County Prosecutor's Office wished to present. Jeff Sauter is with us. Jeff, if you could please step forward, and then following this, we'll be going on to public testimony. Good morning.
Morning, and thank you. My name is Jeff Sauter. I'm the prosecuting attorney from Eaton County and a past president of the Prosecuting Attorneys Association of Michigan. I'm here testifying on behalf of myself, because our association hasn't been able to take a formal position yet, but I do want to thank the chair and the members of the work group for including our association, and I believe I can say that generally we will likely be supportive of all 4 bills. I did want to bring one issue to the attention of the committee, and that pertains to the an amendment regarding the affirmative defense. And I think I understand the reason for the proposed amendment, the concern that the affirmative, with the way the affirmative defense is being interpreted, that at times the defendants, having brought a Section 8 motion, are not allowed to present the issue to the trier of fact or jury. However, and I think that can be improved, and would appreciate the opportunity to work with the committee and the work group. My concern with the language that I believe was submitted to the committee is that it's overbroad and could actually or would actually deprive the trial judge of the essential function of a trial judge in a jury trial, and therefore goes too far. The consequence would be of constitutional proportions in that it would violate separation of powers by taking away the function of the judge. You can't have a situation where either party gets to present evidence to a jury over the judge's determination that that evidence should not be submitted to the jury. So I did want to bring up that one issue. Again, thank the committee.
I do appreciate that, and for the benefit of the committee members and members in our audience, Representative Kavanaugh, who put forward the amendment, has agreed to meet with you, as well as Vice Chair Meadows and Representative Horn, anybody else that is willing to work on that. Again, I just want to reiterate for everybody, we're not voting on anything today. We'll be considering amendments at a later date, so we have a bit of time to work on that and adjust that. Are there any questions for the Prosecutors Association or for Mr. Sauter individually? Thank you for being here. I appreciate it. At this point, then, we'll be moving on. Yes.
Can I just ask one quick thing?
Sure.
Prosecutor Sauter, you may have answered this question, but we were provided this alternative language today. Did that come from your office?
That's actually language I came up with in an effort to help clarify when the affirmative defense should still be submitted to the jury, even if the judge has ruled against it. Yes.
Okay. I just want to make sure we have what you're suggesting that we take a look at.
It's probably rough at this point, but I wanted to offer, I did think that we could perhaps improve Section 8's and clarify when the affirmative defense could still go to the jury.
Okay, thank you very much.
Sure. All right, we're going to move on to the public testimony, and at this point, what we'll do is for individuals wishing to speak, they'll have 2 minutes to do so. We do have a great number of people, so I'm going to do 2 things. We're going to get started in just a moment. We're going to run members right up until noon. I've asked that the board remain open until 12:15. So if you do need to leave because you have something in between this committee and session, that's fine if you've got to go. But we're going to go right up until noon, and then they'll hold the board on the House floor for us. And then we'll return for an hour after session. And we are developing, and I'll announce the way in which you can follow along and determine when we've reconvened. And I'll announce that shortly. We'll start the public testimony then with Michael Grant. And by the way, I'm going to call 2 people at a time because we have an overflow room. So just in case that Mr. Grant is in the other room, I'm going to ask him to come forward. And I don't see anyone standing up. Is Steve Sharp in the room? And what I'll do is on a rolling basis keep calling 2 names just so we can move along efficiently. Kind of an on deck. If you're in the overflow, come in and give me a wave and you'll be the very next speaker. You'll be the very next speaker. Thank you. Please proceed.
Good morning. Thank you for letting me speak today. Good morning. Thank you for letting me speak today. I'd like to get right down to instead of the 4 bills, I'd like to just talk about the 4851 with a bona fide physician. I was diagnosed with colon cancer in 2010. I asked my primary physician to sign my recommendation. I already had one for degenerative disc disease, and he refused to. He told me to go to a pot doctor. This is the way that is going to happen all the way through this process now until things like this can happen. This is a list of studies that were done on cannabis with all of the different diseases and that. So if anybody would like to put in a disease and put in cannabis next to it, you'll come up with some type of a study on it. And for some of the people in here, I'd like to at least tell you that I cured my own cancer with the hemp oil. And my doctors got to watch this. I did not take any other type of medicine, no chemo, no radiation. They removed 1.5 feet of my colon and found there was no cancer left in it, after finding that it was such an aggressive cancer that I didn't have 60 days. This was in December of 2010. At that time, I asked my doctor and my surgeon to sign my card, my recommendation. They refused to. This is going to happen day after day after day with all of the people behind me. There are certain people that need to be specialists. You can't be a specialist with cannabis yet in Michigan. So to go with a bona fide doctor-patient relationship, it is not going to happen with a primary physician that is working with any other type of hospitals or their employers telling them they can't do it. The U of M has already told people they cannot sign this. Allegiance Health in Jackson, Michigan told their doctors not to sign recommendations. I found that this works on so many things. It worked in curing my cancer, not just masking it over with any other type of drugs. That would be about it for me today. And I would like to let you know that the reason that I joined RepealToday.org, a committee for safer Michigan, we're going to try to legalize marijuana in Michigan for anyone over the age of 21. It is because of these type of hearings here.
Mr. Sharp, thank you. You've reached the 2 minutes. I do appreciate your testimony.
Thank you.
Thank you. Mr. Grant, I believe, did step into the room. If you'd like to come forward, and please have a seat. Michael Grant.
My name is Jeremy Rubinson with the Genesee County Compassion Club. We wanted to hear some facility to speak last week.
We did not have a card in, but you are welcome to sit down, and please, if you can keep it to about 5 or 6 minutes, I'll give you a little more time. We just didn't have a card in from you today, so I didn't know that you were here.
Yes, sir. We did print out these presentations for every representative to have. I hope you have those now.
And could you restate your name again, please?
Yes, sir. My name is Jeremy Rupinski. I'm the director for the Genesee County Compassion Club. We're the largest compassion club operating in the state with over 5,800 members. We're happy to be here today, and thank you for the opportunity to be here. I'd also like to thank Representative Horn for his time in meeting with our organization and the time he dedicated. I will be brief in getting into the bills. Our first response here is to Bill 4834. This is dealing with the photo ID. We understand the need for verification and authenticity. As a facility that sees and verifies over 250 patients and caregivers on a daily basis, we can certainly see how this would be convenient, having a photo on the card. However, we currently already have a name, an address, and a date of birth listed on the card. This, coupled with state ID, is more than adequate to verify a person's participation. I'll move on into the second section here for 4834. This is dealing with the 2-year program and the extension of from 1 year to 2 year. We feel this is adequate, and we definitely recommend this. And as most of our patients do have long-term disabilities, and it only makes sense. In the first 2 years of the program, the state did have a report showing, and we have evidence this as Exhibit A in our packet, that the program did generate over $8 million in profit from the first 2 years of registration. And we feel that the program does have adequate funding to have an adequate process in the validating of the cards and also the issuing of the cards. I'll move on to 4853. This is the bill, 4853, this is the bill updating the criminal procedure. The current medical marijuana law already has a provision in it for those who are caught abusing the law, the medical marijuana law, and this is in addition to current drug laws. So I'm not sure if another layer of penalties is necessary, and it also can be cumbersome or quite an issue for people that are caught in the crosshairs of being determined whether they are eligible patient or not. I'll move on here. 4856, this is the bill dealing with transportation. This seems a very reasonable bill on the surface, as no one would advocate to have open intoxicants in a vehicle, or by that matter, certainly not driving impaired. The issue is that we have patients, and that this law was passed to protect patients. And we have a very similar scenario where the person who may have a prescription and may have also a prescription on their persons in a vehicle and could possibly be, as an example, in the cause of an accident. if it was determined that they did have that prescription at the advice of a doctor and they were not impaired, it would not have a bearing on that situation, and they would not be facing an additional misdemeanor as this law would be placing onto our patients and caregivers. And so we do not feel that it is necessary to have further restrictions placed on them. Also, in terms of how this bill is written, we find it to be confusing because it uses the words usable marijuana indicated in the bill, and this has not actually been defined. In the bill, we have a definition of the word medical use and a definition of the word marijuana, but we do not have a definition specifically for medical marijuana. And we need to have a better definition of these terms in order for law enforcement to be able to do their job and to have clarity for patients and caregivers as well. Lastly, 4851, this is the bona fide patient relationship. We understand that there has to be authenticity there in a physical examination. However, as evidenced on section C here, or I'm sorry, my report B, you'll see that the statement of Board of Medicine, the Board of Osteopathic Medicine and Surgery has already been issued by LARA, and this is already being enforced by LARA on physicians regarding the bona fide patient relationship. If you look through the sections that were highlighted for you, it goes on to show the elaborate detail that LARA has already put out in governing physicians, and it actually mirrors the restrictions that are being proposed in your bill. And this is already being enforced. All in all, with these bills and the packages that have been presented here today, we also included some additional information. We realize that part of the bill also deals with the privatization of the program. I'd like to point your attention to Exhibit C, which is from the former MDCH, former issuer of the cards, now with LARA. This report was done on March 1st of 2010 by the department regarding privatization, and it shows that there are concerns with confidentiality provisions listed in the law for patients and caregivers, and it also goes on to list at the end of the report that privatization would not offer a savings of 10% or greater, and therefore financially would not be a win. Furthermore, in regards to the confidentiality provisions, in Section D here of your material, I have the response from former Attorney General Mike Cox, who did go on to say that the program could be privatized and work around the confidentiality provisions. So this is an issue that has already been reviewed and addressed by other state authorities, and if you notice, this request was done at the request of Senator Khan, and it was done after the report was issued by the department itself, showing there was no cost savings. Section E, very quickly, this goes on to bring up one of my other points. We here are considering today the privatization of a program when in December we just spent $830,000 on a printer to get the cards out faster. Many of the bills that are being proposed today are repercussions and blowbacks from the program not being implemented correctly from the get-go. The lack of a council being formed and not having conditions being added has caused for the exemplary or the excessive amount of chronic pain condition being listed on applications, and this has brought concern to you as a potential abuse of the program. However, if potential added conditions were allowed to be added, you may not see that being abused. Same thing with doctor relationships. We've already seen LARA come in and start to impose restrictions, and this has been a blowback from doctors that have not been wanting to participate in the program. We feel that with the current regulations in place and with the current state structures that we have, that many of these issues can and will be resolved. But we do thank you for your careful consideration in all of these issues.
Thank you. And for guests in the audience, this was one of the groups on the list last week. We simply just didn't have a card in today, and I did not know he was here, so I apologize for that.
Thank you.
Are there any questions? Seeing none, thank you for joining us today. At the suggestion of our good Minority Vice Chair Meadows, I want to call 6 names. I'm going to ask them to come and take the 6 chairs in front of us, and that way we can continue our... What I'm trying to do is just make sure that we can hear from everybody today. So the next, Michael Grant again, if he is here today, Whitney Hickman, Brandy Zink, Dr. Jean Ragland, Vicki Nicholas, and Matthew, well, they want to come up together, so I'll call them separately, Patrick McCarthy. And if you want to identify, just give us your name as the others come forward, then we'll...
Sure. My name is Whitney Hickman.
Good morning. Whitney Hickman is first. Go ahead.
Can I start?
Hello. Thank you for having me. I'm a third-year law student, a mother of 7, and a cannabis advocate. In the previous Judiciary Committee meeting, Representative Brown referred to medical marijuana as a prescription medication, to which Chairman Walsh quickly corrected her in stating that it can only be recommended and certified. However, in the agenda of the description of House Bill 4853, it states that it will cover criminal procedure, sentencing guidelines for the crime of selling or providing medical marijuana to unprescribed users implement. With that type of wording being unprescribed, that would open up both certified and uncertified users of medical cannabis and caregivers to be prosecuted within the law. No one in the state of Michigan can be prescribed medical marijuana. The violation of the act is already outlined in the original act. However, the description of the bill needs to reflect uncertified instead of unprescribed. Michigan voters believe that medical marijuana is medicine. Marijuana then needs to stop being treated as a Schedule I drug and needs to be treated as medicine. In no other over-the-counter medication or pharmaceutical medication are patients forced to lock their medicine in a trunk, in a case, and have it inaccessible from the interior of their vehicle. With any prescription medicine, a patient is allowed to have their medication accessible from any area within their vehicle as long as the patient possessing the medication has their name on the pharmaceutical bottle. With Michigan already having penalties for driving while impaired, MCLA 257.625 1A and B, no language needs to be added to the act to inform Michigan drivers that they cannot use their medication while driving. This bill, again, is circumventing the law by singling out medical marijuana patients from traditional pharmaceutical patients and turning law-abiding patients and caregivers into possible criminals. I will leave you with this thought. In 2008, Michigan voters approved cannabis as medicine by a margin of 3.3 million voters. Less than 2% of those voters are actually certified under the act. In public opinion polls, these numbers are rising. I urge you to not focus on your personal opinions of the plant or what a small number in your district may feel, but to remember that this act was passed in every single one of your districts. Remember what the title in front of your name states, and to remind yourself who your constituents are this election year. Thank you.
Thank you. We'll go to your left. To your left. If you could please state your name.
Good morning. My name is Brandy Zink. I reside in Detroit, Michigan, and I represent this group, Americans for Safe Access. We are the nation's largest medical cannabis advocacy group with patients, caregivers, physicians, attorneys, and professionals, and citizens who support medical marijuana. That being said, I thank you, Chair and Representatives Kavanaugh and Rep. Horn, for your compassionate leadership in the work group in considering this very important issue. This issue that came before us, since the voters passed this law, overwhelmingly so, has brought much relief to many people across the state, and I believe that the Medical Marijuana Act is an overwhelming success for the majority of the participants, and those who are unfortunate to have law enforcement encounters will likely tell you otherwise. That being said, the law has not been implemented in its entirety, and we urge you to consider that because the act has not been implemented, there are these issues that we're addressing in these bills before you. We'd like to see the act be implemented and to have the panel to address the conditions to be added, to have that panel convened. That would be a great help to the vast majority of people in this program, has been stated earlier. To address the bills before us today, the House Bill 4834, the photo ID, I feel if it could be implemented and better serve the citizens, where we could get the cards in on time, and if we can ensure the absolute confidentiality, the sacred trust, if you will, that the patients and caregivers who joined this registry, we must protect their information at by all means necessary. So privatization, we support if it would provide better service and get the cards in a timely manner, and we would support the photo ID. The bona fide patient-physician relationship has been addressed many times, but within that bill, I would like to add there is the question of the enclosed lock facility. Certainly, we'd want to consider an outdoor facility being somehow to be defined as a secure enclosed lock facility. Plants should be grown outdoors if they're secured and locked. The penalties for selling marijuana in violation of the registry, I feel that the bill is
Ms. Zink.
properly addressing the sentencing guidelines.
That's been 2 minutes. So we're going to
you.
continue on. And for anyone who has additional comments, you can email any member of the committee with them. We will still continue to consider the information. Sir, if you could please give us your name. Oh, and by the way, when you're done, you're free to stay or return to your seat. You don't have to stay. Sir?
Thank you very much. Good morning. My name is Dennis Hayes. I'm here on behalf of Dr. Ragland, who submitted a letter. All of what you've all received copies of the letter. Dr. Ragland is unable to be here. There was there were funerals he had to attend. Just briefly summarize his letter. Dr. Ragland, who practiced for 30 years as an emergency room physician, was concerned because this bill that's proposed, 4851, would create issues with regard to his entire medical career. The definition of a physician-patient relationship is a well-worn road and one that does not need modification for purposes of the medical marijuana patients. In addition to which, the bill would require a psychological examination, which would in fact disqualify my regular physician who has issued my recommendation, and it poses a dramatically increased level of standard of care by which almost no physicians would be qualified. There are not enough psychiatrists to give psychological evaluations. Obviously, there are conditions which any physician can determine as a psychological condition that requires further examination in terms of their application of the standard of care. Further, the standard of care that you would impose in this bill with regard to the physician-patient relationship is confusing apples and oranges. The standard of care is what each of these physicians in each case uses to evaluate their patients, and the statute itself provides the conditions that are in fact are qualifying conditions in which this physician has to use to evaluate their patients. Finally, I would urge you to look again at Dr. Ragland's closing statement, that the Hippocratic Oath, which is first do no harm, and that you would really want to be careful with this legislation because you could create a very harmful situation for patients and for physicians. Thank you.
Thank you, sir. We'll go over to my left. Will you please have your name?
Hi, my name is Vicki Nichols. I am a lifetime resident of Macomb County, Michigan. I am a taxpayer and a homeowner. I am also a Michigan medical marijuana patient card holder. I was diagnosed with juvenile rheumatoid arthritis at the age of 18 months old. Rheumatoid is a progressive, often fatal disease in which the immune system attacks the body's healthy tissue. Along with destroying the body's joints, it also attacks the heart, lungs, and digestive tract. 2.5 million Americans suffer from rheumatoid. As a 2-year-old, the doctors had me taking 17 baby aspirin per day. By the time I was 12, naproxen was the new drug on the market. I was on naproxen for the next 15 years. I excelled in school despite my agonizing pain. I graduated from Oakland University, and I got my certified public accountant license and had a great career for 8 years. Even after having bilateral hip replacement surgery at the young age of 27, I continued to work full-time. My disease kept progressing. By the age of 30, I developed degenerative disc disease and colitis, which are a direct result of the rheumatoid. This was the final straw. My doctor put me on disability. During the last 10 years, I have been on chemotherapy and biologic treatments for the rheumatoid and colitis. About a year ago, I could no longer afford the skyrocketing copays for all the prescriptions I had to take. The copay for my biologic alone was $1,000 per month. Along with having to get epidurals in my cervical spine, I was on 12 prescriptions, including fentanyl. My hands were so swollen, I could barely drive or hold a cup. I was then introduced to marijuana oil at a local compassion club. After using marijuana oil on my hands for only a few days, the swelling disappeared. My doctor was amazed. I also use marijuana orally to fight inflammation and severe pain. I have reduced my prescriptions needed from 12 to 5. I am happy to report I have not had a major flare in months.
We've reached 2 minutes. No, we have many
one
people
sentence.
here.
I do not use medical marijuana to get high. I am not a stoner. This plant is a miracle for me, not an illicit drug. Please consider my story for any changes to the Act.
Thank you. There are many people that are wishing to speak. Ladies and gentlemen, we do have many people that are wishing to speak, and I do wish to underscore that we have been taking in input from patients, doctors, lawyers, police officers for months. We're just trying to be efficient in making sure that those who took the time are going to be heard today. Sir, if you could please give us your name.
Thank you, Chairman Walsh. Good morning, members of the committee. My name is Matthew Abel. I'm a lawyer in Detroit. I've been an attorney for 25 years in Michigan. I'm the founder and senior partner of the law firm Cannabis Counsel. We're a 4-attorney firm that only handles marijuana cases and clients.
Mr. Abel, did I call you up?
I was informed that you had, but I was out of the room when you were calling names, and someone waved me up here.
Did you turn in a card today?
I did. I turned in a card last week and today.
All right. Let's continue.
Thank you. I am the executive director of Michigan NORML, the national organization for the reform of marijuana laws. I'm also the campaign director of the Committee for a Safer Michigan. You've probably heard about our constitutional initiative ballot proposal. I was the attorney for the first case that actually went to a jury with the affirmative defense. There was a case, the people of Sylvester versus Sylvester Vanderbutts in Cass County. Mr. Vanderbutts was convicted, and the case went to the Court of Appeals. That case was affirmed. There was a confusing jury instruction in that case. There was a statement that the police can only obtain whether a card is valid. That's not true. That's the first level. The second level, if the card is valid, they can make a second inquiry. And if the first inquiry was verified, then the second inquiry will produce the name and address of that cardholder if, in fact, the cardholder has checked the box on the application form allowing the release of the information in that time. I have no problems with the sentencing guidelines. I think it's entirely appropriate. I've been a criminal defense attorney for 25 years. Every crime ends up going in the guidelines if it's a 2-year offense or higher. That seems appropriate to me. The transporting marijuana bill 4856 should be limited to usable marijuana only, please. And I'm concerned that it amends the penal code, not the Michigan Medical Marijuana Act. So when you put it in the penal code, when someone thinks that they're going to read the Medical Marijuana Act and understand what all the laws and rules are, because that's in the penal code, not in the public health code, people are not going to get that. There was a letter sent out from Lara in January from Ray Ramsdell. I think you ought to question her before the committee. She was threatening doctors, is my understanding. And the biggest issue, the enclosed lock facility, it seems that this language would prevent someone from growing outside. If that's really what you want to do, you ought to say it out loud. And if you don't intend to prevent people from growing outside, then there ought to be some way that people can do that without running into law enforcement problems.
Thank you, sir.
I have much more comments, and given the opportunity, I'd be happy to speak further. Thank you.
Thank you. Sir, if you please give us your name.
Hi, my name is Patrick McCarthy, and I come from Grand Rapids, Michigan, and I represent myself and those like me. Excuse my lack of eloquence and familiarity with any of the specific bills, but I'd like to share a short story. I've recently graduated from college, and I never would have been able to do so without medicinal marijuana. Prior to medicinal marijuana, I have been suffering, and well, still do suffer from tic disorder and akathisia, an inability to sit still and a constant restlessness. That constant restlessness in school would make it impossible to pay attention in any of the courses because I would be constantly writhing in my seat and unable just to focus or pay attention in any way. I've tried different medications through different doctors. I've tried, I believe, 9 different medications over 2 or 3 years, all of which had nasty side effects and none of which worked. I was turned down by multiple doctors when I spoke with them about medicinal marijuana. I was finally able to pursue that option, and when I did, that took away my akathisia. I was able to sit still, I was able to focus, and I was able to graduate from college. But what I would like to bring to everyone's attention is the fact that I'm scared to be involved in this. I think that too many things are too vague. Too many things are constantly changing, and I urge explicit clarification of many of the bills and many of the terms in the bills, as many others have done so. Thank you.
Thank you for joining us today. All right, I'm going to call off the next 6 names. If people could please come forward and be seated. Thank you all. Robert Redden, Scott Woods, Matthew Taylor, and Becca Hollinsworth, Gersh Avery, and Janine Kemp. Sir, if you'd like to start, and if you could just give us your name, sir, if you'd like to start. You're the first to sit down, so we'll start there.
Thank you. There we go. Good morning. My name is Scott Woods. I am Executive Director of the Berrien County Compassion Club. I'm also a patient and a caregiver, and I'm a moderator for the Michigan Medical Marijuana Association's website. I want to thank you all for allowing me this opportunity to speak. I come to you this morning to oppose the bills before you and to plead for your help in protecting the sick that we voted for in 2008 in passing the Medical Marijuana Act. As all of you have heard from earlier testimony, the laws the voters passed have yet to be followed by the courts or law enforcement. The very people we voted to protect are being persecuted and are scared to death of being thrown in jail without the ability to raise the defense, or being allowed to raise the affirmative defense in court. Even as simple and basic as what we voted to do with this law, protecting the sick from being arrested, has yet to be followed. The law has yet to be implemented. The sick are still hunted, jailed, and law enforcement has made a mockery of our democratic system of government and has just disregarded the will of the people. They are still persecuting the sick and the dying in the state by the bidding of our Attorney General's slanted opinions of the Act. The law is very simple, it's very easy to read, it's very easy to follow by both parties. But no matter if we patients follow the law to a T, law enforcement is still hunting us and is still putting us in jail, and the courts have just denied anyone from being able to raise the medical marijuana defense. This has to stop. This is the reason I'm before you today, to oppose the bills before you and all bills pertaining to the Michigan Medical Marijuana Act. How can you amend a law you have yet to follow, to implement? Why do you still want to put the sickest and weakest in our state in jail? Why is it, as sick as I am, and as my members and my patients are, why would you make me and us come before you to plead for your help?
At 2 minutes.
Okay.
Thank you.
Thank you.
All right, we'll go down to this end and continue through. Welcome, and if you could give us your name, please, because I called in a group, it just helps with our records.
Good morning. My name is Janine Kemp.
Thank you.
Hi, good morning. I'm a medical marijuana patient, and I was a healthcare professional. Similar to Vicki, who spoke earlier, I have lupus, which is an autoimmune disorder, and that causes similar problems with inflammation and chronic pain, joint pain, and nerve pain. I read about how marijuana could help with my neuropathy, a pain that I deal with every day, and I found that it was something that would be something that would work for me. And I just wanted to stand up and tell you that I took charge of my health. I have a doctor who promotes healthy living. I lost 50 pounds. I started using natural treatment, medical marijuana, instead of pharmaceuticals and things that could kill my kidneys faster and my liver faster, because the disease that I have will eventually do that for me. I wanted to thank you for having us here today. I did want to add that it is a problem with the dispensaries being closed because some of us don't have safe access to medicine at this time.
Thank you. And if you don't know, we do have another work group trying to address that issue. That may take a bit more time, but that is on a future agenda.
Thank you.
Go ahead, folks. I think you came up together.
Thank you, Becca. I appreciate it. My name is Matthew C. Taylor, and I'm from Mount Pleasant, Michigan. I own a Big B Cafe, and I also started CA with my partner, Brandon McQueen, State versus McQueen case. You may be familiar with it. I am very happy to be here today on March 8th, my birthday, actually. it's kind of a gift for me because I've tried to contact you guys at different times, and it's nice to have you all here. But my main point here is I want to show some people, especially folks who are opposed to medical marijuana, that we actually have a lot of issues that we share in common. I own a cafe in Mount Pleasant, so obviously I have a vested interest in the public health and safety of Mount Pleasant. But I want to express it in the bills here on the table to not waste time. So, number one, transporting things in your trunk or in a case, I mean, that's just good practice as far as I'm concerned. If you had methadone or another substance like that, it would also have to be in a locked case. My main thing here is not so it's going to help police officers who pull someone over to have a reasonable assurance if it's in a case that it's not in quick access. They haven't been smoking it while they're there, which could give us less court cases in the course of law, which I'm sure we could all use a few less court cases. It also gives police officers an option, as opposed to seizing what they see, to just issue a fine and say, hey, I could have ruined your day today, but here's a ticket instead. As for the bona fide doctor-patient relationship, a lot of help needs to be done here. I mean, we do have so-called clinics that have not a single examination bed in it, not a single stethoscope, not a single blood pressure monitor, and there's absolutely no background checks for who could be running these places. In fact, I happen to know of not anyone here today, but there's actually a Compassion Club president who is on the CSC registry, as far as I know. So obviously we need a lot of help and more background checks, and one thing I would suggest is if you want one of these clinics, it should have the accoutrements of a doctor's office, an examination bed, blood pressure monitor, the things you need to do to have a real examination. And finally, with the 4834, I have long had the goal of helping this to become a legitimate trade, and that means people who used to hide need to come forward. I have no problem at all with pictures being issued on cards. That could help end some confusion. The 2-year thing is good. And as far as sharing information with police departments, I think it is important that we bridge these gaps between the medicinal community and law enforcement.
Mr. Taylor, you're at 2 minutes.
Thank you. Oh,
thank you.
Inspections and end investigation upon confirmation of the number.
Thank you. And Ms. Hollinsworth, correct?
Hi, I'm Becca Hollinsworth. I am one of the co-owners of the Robert C. Randall Memorial Wellness Center. Robert Randall was actually very well known in Michigan. He fought for glaucoma, and actually on October 22nd, 1979, Michigan actually implemented a program based for cancer and glaucoma patients. One concern I do want to address, I am a patient, I am a caregiver, I am a mother who is 31 years old. I have macular degeneration, I have cataracts, I have dry eye syndrome, I have severe sensitivity to the sun, and I also have glaucoma. This has been life-saving. It allows me to go outside and to see my children. As far as the doctor bona fide relationship, we understand that there's a concern that it's a signature mill. We are very supportive of this bill. We do encourage an actual examination at our clinic where there is the equipment there, blood pressure is taken, and we are all for having follow-up appointments. We truly believe this is a medicine, and if you look at the research on the Granny Storm Crow list and many other various information wells, treatment can be very specified down to the strain, to the salves, to the topical oils, to the many different varieties of the medication. So we are totally acceptable with what you have put in front of us. One concern we do have is our veteran population. I speak on behalf of them because, as it has been brought up, the VA will not sign certifications. That leaves a huge population of our veterans here in Michigan very vulnerable. I know that Representative Graves, you're very brand new onto this. One thing that you had mentioned that does concern me is, before getting into this industry, I was a workforce employment specialist. Our economy in Michigan is failing horribly. People do not have the money for the co-pays, so we really encourage to have clinics and have the follow-up appointments to ensure that it's not a mill. But at the same token, leave the options open for the people whose primary care doctors will not sign. Please do not block off that many patients from access. Thank you.
Thank you for your testimony. Sir?
Chairman, Representatives, thank you. My name is Gersh Avery. I'm a medical marijuana activist, a medical marijuana specialist. I'm a cancer patient. 3 weeks ago, I was in my doctor's office, St. Joe's Hospital, right between Ipsy and Ann Arbor. He went in with a scope and looked at the inside of my bladder. There was 2 doctors present. The one said, "That is cancer right there. There is room in the OR if you want to go right now. If not, we can take care of this right here, right now. We can go in and cauterize it and take it out right now at this moment." And I said, "No, sir, not today." And he said, "What?" I said, "Not today. This is my body. You're not going to rush me into an operating room. I'll take care of this myself. I'll knock this cancer out within 30 days. He says, "You're not going to do that." And I says, "I'm sure that's what you believe, sir." He says, "That's cancer." "Yes, sir, it is." "All right, I'll give you 6 weeks. 2 weeks later, I went in to get my CT scan, and I had my target at that point was for a 50% reduction in the size of the tumor. I missed my target. It was completely gone. Gone in 2 weeks. I just got the results yesterday. The medicine I use is the same medicine that Steve Sharp, who spoke with you earlier, was using. It's a concentration of marijuana called hemp oil. This is an essential oil concentration of the cannabis plant. The current law allows for us to make preparations thereof. This is barely legal, but even just being barely legal is now keeping people alive. It is dissolving cancers out of the middle of people's bodies today. Please give us room. Now, as for these laws are intended to remove people from the ability to be able to do this legally. In other words, they did everything that they could to become law-abiding citizens now, and after becoming a law-abiding citizen, you're going to turn them into criminals again, after all they've done. How many people? 25,000 people, 25,000 sick people that will become criminals because of this activity here now.
Thank you, sir. Thank you all for joining us today.
Thank you.
Thank you for your time and consideration.
No questions then? I'm teasing.
Moving on, our next folks would be Joe Romano, Gareth De Halicourt. I apologize if I have not spoken that. Gareth De Halicourt, Christopher Go, Christina Offernan, thank you. Christina Offernan, Madge Morgan, and Dave Warsaw. And again, we'll start with those who reach the table first and go around. So, sir, and if you couldn't, just for record keeping, give us your name.
Yes. Good morning. My name is Joseph Romano, and I'm a patient and caregiver and live in Detroit. First, I want to thank Representative Horn and Kavanaugh. I've had the opportunity to meet them back in the summer, and really just amazed by the amount of time and effort they've put into trying to understand this whole issue. This morning, I want to make a point of asking every legislator to subscribe to an observation that I've heard Representative Kavanaugh make a number of times. The Medical Marijuana Act should be viewed as a public health issue and not a public safety issue. I won't rehash each of the bills, but would just simply say that the specific issues identified by Cannabis Patients United last week and the representative of the criminal defense attorneys, Tom Loeb and Neil Rockheim, I support. My one personal observation is that I strongly oppose any expanded access to the registry outside of a warrant. My reason for this is straightforward. The people that might abuse the access comprise the leadership of the opposition to the Medical Marijuana Act. As elected officials, you have the personal experience of dealing with the losing side. They never go away. Would you trust your losing opponents to do the right thing? For the Michigan Medical Marijuana Initiative, the opposing groups were the Michigan Citizens Protecting Children and the Prosecuting Attorneys Association of Michigan. In every voting district, the citizens of the state of Michigan rejected their notion that medical marijuana is about public safety. For the Michigan medical marijuana patients, the losing side has not gone away. They're using funds collected from the registry program to demonize us. The chairman of the opposition, Michigan Citizens Protecting Children, is now the chief legal counsel to LARA. They've installed a retired sheriff to head up the day-to-day operations of the program, and they use state funds collected from registered patients and caregivers to tour the state, bringing their message of protecting children and public safety to every city and county in the state. To ask us to accept that they'll do the right thing with confidential registry data is asking too much. I've been here for all 3 hearings on these bills and the presentations by Representative Walsh, Horn, and Kavanaugh, as well as numerous insightful questions asked by the representatives, leave me with a feeling that the majority of the reps in this room recognize that medical marijuana is a public health issue, and I thank you for taking the initiative to work with our community.
We're at 2 minutes.
I'm there.
All right, thank you, sir. We're going to go to your right. Welcome.
Hello, my name is Christopher Galt. I'm from Waterford, Michigan. I'd like to excuse myself. I'm talking through pursed lips here. I'm not very confident about my teeth. I'm a patient. I'm surviving cancer, prostate bladder cancer, back surgery, and surviving taxes. We all have our own conditions here. I've had many of doctor's visits. They've all been pretty bona fide to me. I know what they do every time. It's a pretty simple procedure. I'm on once a year with my cancer doctors. That seems to be the backup. I just wanted to thank you.
All right.
Thank you.
Well, thank you for being here. I appreciate it. Sir?
My name is David Warsaw, and I am a medical marijuana user and a caregiver. I just want everybody to understand that the side effects from medical marijuana, whether you want to call it a high or whatever, is far less than anything I've experienced from codeine or morphine or painkillers like that. I ran myself over accidentally from stem to stern with a 2-ton tractor, and I'm pretty darn lucky to be walking around and living these days, but I don't take any pharmaceuticals or anything other than medical marijuana and vitamins, and I try to live a healthy life. My doctor is very liberal, and I'm sure he backs medical marijuana. I've told him I use it, but I did not get my paper signed by him because sometimes these doctors don't want to give you a pain pill if you're on medical marijuana, and every now and then I do need a pain pill. But I'm just against these bills because we don't need to be made criminals. People don't need to be worried about going to jail because they want to take an alternative medicine, if you will. A lot of people will not even consider medical marijuana because all the propaganda and things that have been spread over the years about it. I've used it for many years, illegally obviously, and it's never hurt me. I've seen people that took too much. You go to sleep, the next day you're okay. Alcohol is a far worse product. You don't need to keep your alcohol in the trunk, do you, or locked in a case? My pain pills are in my armrest in my vehicle. They don't need to be in a case or locked up. If you're a responsible person, you're going to do the right thing. If you got to tell people to be responsible and lock things up and not do it, then they're probably not going to. Thank you.
Thank you for being here.
Hi. First, I would like to thank you for your time and the opportunity.
Could we please have your name for the record? I'm sorry to...
My name's Christiana Offerman.
Thank you.
I'd like to thank you for your time and opportunity to speak with you today. I'm a registered active voter, home health care worker, mom, fibromyalgia patient, activist, and medical marijuana patient and caregiver. I have been registered cardholder since early 2009. I was going to address the House on the first bill looking to be introduced, but after much thought, it has occurred to me that the MMMA, the Michigan Medical Marijuana Act, already speaks on the topics looking to be cleared up with these amendments. My feelings are these amendments would create more of a problem for the patients, exactly the people whom this law was created and voted for. The idea that the MMMA needs to be redefined, altered, or amended is ridiculous. What needs to happen, in my opinion, would be our local governments would uphold and enforce the MMMA as it stands. How can we be considering amendments to a law or act before it has been implemented the way it was intended? The law was wrote and intended to be used by people with various ailments, even the ones who don't appear sick, such as myself. This law is awesome and amazing. Michigan and its residents could benefit from cannabis on a number of levels, even fiscally. Officials are having and have always had a very difficult time with voter-initiated amendments. Most laws that come into play are wrote and implemented by lawmakers, thus making it easier for them to follow. Michigan and its residents have an amazing opportunity to take our health care and the future of Michigan into its own hands, the people. The only problem I see with this initiative is the local and state officials acknowledging it and implementing it without trying to interpret it or define it. To believe that the basic human rights to quality of life and wellness could be taken from a citizen who resides in our country is very disheartening, as our country was not built on this thought process. Cannabis for me is a lifesaver. The quality of life that I lived and my family experienced prior to cannabis therapy would have done myself and my family in. The condition is real and causes constant and chronic widespread pain for me. Cannabis has eliminated my need for 3,600 milligrams a day in Neurontin, which numbs up the central nervous system, so I can walk as if I'm drunk.
Ms. Heffernan, we're at 2 minutes.
Okay, thank you.
Thank you all for joining us.
Thank you.
We'll now call forward Renee Palmore, Dennis Alsop, Gary Herbeck, James Barber, Carolyn Wright, and Anna Jennings. Welcome. Would you like to begin, please?
Certainly. I'm Patty Alsop. I'm here for my husband, Dennis. He suffers from severe ankle arthritis and also bladder cancer. He had numerous tumors removed and, as suggested by his oncologist, had one chemo treatment. He ended up being in the 1 percentile of the severe reaction of that mitomycin drug. Mitomycin has a 7-page MSDS sheet. It needs to be disposed of as a highly caustic, hazardous material. He didn't sleep for 9 days. He lost 20 pounds in those 9 days, and he almost died from the treatment, not the disease. If it was not for the cannabis, I'm sure he would have died. The doctors told him that there was absolutely nothing they could do to reverse the damage they had done, or that the drug had done. It was unintentional. It was all within protocol. He was that 1%. He started ingesting medical marijuana, and that is what helped reduce the scar tissue in his bladder. Immediately after the damage, he had a 150 milliliter capacity in his bladder. That is not quite 3/4 of a cup. He voided constantly, and it was excruciatingly painful. The initial doctors thought he was a drug seeker when he would call and complain about the pain, the excruciating pain. Second opinion doctor said, "I'm sorry, there's nothing we can do. We haven't seen this happen. I'm sorry." So if it were not for having the ability to access medical marijuana, he would be in a seriously bad way. It has helped him immensely. On his one of his last visits to his oncologist in March of 2011, the doctor actually said, "When you came to me, your bladder was a minefield. It is drastically improved. What do you think it is?" He told him it was the cannabis. This doctor would not sign his certificate. He had to get it from his ankle doctor for his ankle pain. So the bona fide relationship is established, but it wasn't for the real cause of his pain and his disease.
Thank you for being with us today. We've reached 2 minutes.
Okay.
Thank you.
It should not be a crime to be well.
Thank you. Sir?
Hi. My name is James Barber. I'm a medical marijuana patient and activist. I believe Bill HB 4834 is bad for patients. This bill will violate a patient's right to privacy. Putting our photo on a card is not privacy, nor is telling law enforcement that you are a patient. I don't want an officer to be prejudiced towards me in a traffic stop because a check revealed I was a medical marijuana patient. People who take pharmaceutical pills don't have to be subjected to this. Why not register all people who use pharmaceutical pills? This is a privacy and prejudice issue. If you want to label me a United States citizen. Thank you.
Thank you.
Thank you. My name's Anna Jennings. I'm here as an advocate for my boyfriend, Patrick McCarthy. He has akathisia and the tic disorder that he described earlier. And I just advocate this so much because as a loved one who watches the one that they love go through so much pain, it's hard. And you watch them go through medication after medication with horrible side effects, and you wonder what the doctors are even thinking sometimes. And then they can be put on, they can take medical marijuana, and there aren't side effects. They're happy, they're healthy, they feel better. And Patrick was able to graduate from college because of this. He almost had to drop out, and he's a smart guy. He has a physics and a math degree, and he needed this. He needed to have the medical marijuana, and I'm afraid that with all the different laws and all the different things that are happening with these bills, that he's not going to be able to have that anymore, and he needs it. He needs this. Thank you.
Thank you. Ma'am?
Good morning. My name is Carolyn Sifferman, and I am not a medical marijuana user, but I have a son.
Did we call your name?
Well, you called right, but
oh, very good.
That's my maiden
Thanks.
last
I just want
name.
to make sure it's
right.
Just sometimes when people are here on behalf of others, I'm just trying to keep straight.
Well, I am here on behalf of my son. His name is Eric. Eric is profoundly deaf. I found out Eric was deaf when he was 2 years old. I was a single mother. I was very young, and we learned sign language together. We have a very special relationship. When AJ was about 22, he was working for a lawn care business and developed some severe back pain. Took him to the doctor. They gave him some Darvocet and some Soma. This pain progressed along with severe headaches. Over the course of approximately a year, he was prescribed numerous medications, narcotics and antidepressants. They were not helping. He became more and more depressed and had to quit his job because of the severe pain. He continued to live on his own, but he was using Vicodins, Elavil, Valium, Soma, Naproxen, and any other prescription medicine that they gave him. He was extremely angry and frustrated. He felt like nobody was listening to him because he was deaf. I was so concerned for AJ's safety, I call him AJ, that I had to move him back home. Now, he was about 25 at this time. I had to move him back home because I was afraid he was going to overdose on all these narcotic medicines. As time went on, there was numerous events of different hospital visits, different stays. Finally, I had to have him admitted to the psychiatric ward. They tried to do a spinal tap, took 9 times to get the spinal fluid out, sent him to pain management. He was diagnosed with ankylosing spondylitis, a severe blood arthritis that makes your bones and your joints fuse together. At this pain management clinic, they started prescribing morphine. They added methadone to it. When my son got his medical marijuana card, he was taking 140 milligrams of methadone a day. He was a drug addict. He was a physician-assisted drug addict. He finally decided that he wanted to try the medical marijuana. I said, fine, if that's what you want to do. We went to our family doctor. He would not prescribe this for my son. No way, against policy, wasn't going to do it.
We're at 2 minutes.
Well, he did get the card. He's off all of his narcotics. He's back to being a normal 28-year-old man, as many of you guys are now. So I have to advocate for it.
And I thank you. Sir?
Hi, my name's Gary Herbeck, and I want to thank you for giving me the opportunity to sit here in front of you and voice my opinion. First of all, I don't think the bill needs to be adjusted or amended. It's clear in every aspect when I read it. My personal situation is I've had numerous car accidents. I've got fibromyalgia. I've got nerve lesions, numerous things that I found that cannabis was able to keep my pain under control for a year. Then I went in front of a judge for a traffic violation. He told me that I was a drug addict and that he was going to make it impossible for me to use marijuana. So for the last year, I've been at a pain management specialist also, and I'm on Suboxone, which is a pretty dangerous drug in my estimation. I don't like the side effects, and I really don't like having to pay $1,000, $977 a month for this pain medication, when I could control it with a couple $100 worth of cannabis, which, quite frankly, the side effects were much more manageable. But I support this bill. I support it the way it stands. I don't think it needs to be changed. And I don't think that we as patients need to be treated as criminals by the judges or the police departments. You know, they have to look at us as sick people, not criminals. That's all I've got. Thank you.
Thank you for joining us this morning. All right, if the following could please step forward. Albert Rush, Dennis Pilak, or Pilak, Dennis Pilak or Pilak?
Pilak.
Pilak, thank you. Tricia Kreider, Beverly Hines, Ann Wilbur, and Jeffrey Hurst. Mr. Pilak, if you don't mind beginning, I'd appreciate that.
Sure. Greetings, Representative Walsh, and to all committee members and all interested parties concerned for the preservation of the liberties granted under the Michigan Medical Marijuana Act, the most significant act of democracy in Michigan's recent history, a people's initiative approved by 63% of the voters. My name is Dennis Pilak, and I am a medical marijuana patient. I am also a former teacher. But more important to this hearing is my 48 years experience with marijuana, especially religious use, for which I and my family have paid for with the sacrifice of our lives, finances, and property. You got me. I could tell you my life story of marijuana use at the risk of making you cry, but I won't. I'm here to expose the committee to some of the harms I see to the citizens, especially children of medical marijuana patients and caretakers, by the blind acceptance and tolerance of the prohibition of marijuana as a continued policy for Michigan and America. Marijuana is classified in the Controlled Substance Act as a Schedule I drug. The federal government's premise that marijuana is evil and harmful and uncontrollably abused and is medically good for nothing is factually false, and the citizens of 16 states agree. I start with a report of the Global Commission on Drug Policy entitled War on Drugs. This is a June 2001 report. Was compiled by a study of 19 professionals from 13 participating countries, including the USA, and concluded marijuana to be out of place in Schedule I and recommended the current schedules designed to represent the relative risks and harms of various drugs were set in place over 50 years ago when there was little scientific evidence on which to base these decisions. This has resulted in some obvious anomalies. Cannabis and coca leaf, in particular, now seem to be incorrectly scheduled, and this needs to be addressed. Within the framework of this report is real evidence of the failed war on drugs with greater consequent harms indicated to the lives of the people caused from law enforcement rather than the drug used, especially marijuana, the most widely illicit.
We're at 2 minutes.
That was 2 minutes?
It was.
Okay.
Thank you.
You're welcome.
Sir?
Thank you, Chairman. My name is Jeffrey Hurst. There's a few things I wanted to address with these particular bills. First being the bona fide doctor-patient relationship. Instead of defining it, I'd suggest you remove it. If you're not comfortable adding this to the health code, applying it to all Michiganders and their doctors, just cross it out of the medical marijuana law. You can't do that. As Sergeant Gill of the State Police testified last week, they don't need to know a patient's medical condition, who their doctor is, or where that doctor is. So let's narrow the scope of the information available through LEAN and clearly define what will and will not be available. I would like to point out that the position of the Office of National Drug Control Policy, as stated by Prosecutor Stecker, is contradicted by the position of the American Medical Association and literally thousands of leading doctors and scientists from around the world who say that marijuana does have medical value. I would also like to point out that that position is contradicted by U.S. Patent number 6630507, held by the U.S. Department of Health and Human Services. This patent is titled Cannabinoids and Their as Antioxidants and Neuroprotectants. This patent clearly states and outlines just two of the many uses of cannabis as a medicine. It has been stated repeatedly that distribution will be discussed later. But with the state of our state's economy, I don't see how you can ignore such a potential source of income for the state while also failing to address the biggest problem with the medical marijuana law. None of the proposed bills is so vital that it can't wait while a distribution system is hammered out. I encourage you to create a commercial distribution system in addition to the current patient caregiver system, tax it, and fix our roads. Thank you.
Thank you, sir. Whichever would like to go first. Welcome.
My name is Tricia Kreider. I am a T10 paraplegic due to a car accident in 1994. Due to that, I've had chronic pains, all sorts of infections, whatnot. Doctors had me on over 150 pharmaceuticals a day, 8 of them being opiates of the highest opiates, Vicodin, morphine, fentanyl. They kept saying this is going to help you. They'd give me another medication to stop the side effects, and next thing you know, I was in bed 24/7. Ill, just miserable, depressed. I am also a mother of 5 children and happily married. I am very, very pleased to say that because of this act in 2008, I am no longer on any prescriptions. I am no longer in bed all day long or very much at all. I am up every day being very active with my children. I was able to coach a basketball team with my girls. If it wasn't for this law, I truly believe that I would probably be dead now. The horrible side effects, the horrible sicknesses and hospitalizations that all followed from simple pains, and not to mention now I have what's called celiac disease, which all of those medications they had me on really did a number on my digestive system. So again, if it wasn't for this law, I would not be able to. I wouldn't be alive. I wouldn't be able to wake up in the morning and greet my kids off to school, as well as just enjoy the day and be all in all healthy. So I really pray that this law gets the bills needed and everybody could be healthy and safe and not criminals.
Thank you for being here.
Hello, my name is Ann Wilbur, and I want to thank you all for letting me speak to you today. And I'm here today because I'm very, very concerned, as I've told Mr. Patalia before, about what is going on with these bills. In particular, this expanding or lowering of the bar of the probable cause needed to get a warrant. I am very disturbed by this, and I don't think it would be a problem if the law enforcement agencies were following the law as written. I've heard Lieutenant Gill of the multi-jurisdictional task force talk about that many of these people or caregivers or patients that they've gone to and to check into their grows that they've had overages is something he's talked about. But I don't think that he expanded to you that these multi-jurisdictional teams are not accepting paperwork. There's many instances of people who had, 3 or 4 sets of this paperwork that's fully in order, and they're not accepting that. They say, we can't accept that, and they are then taking those plants from those patients and caregivers, stealing them, in my opinion. We've heard Lieutenant Gill talk about confidential informants and how this is the main way that they're able to find probable cause to go into caregivers' homes. But these confidential informants are generally people who have serious crime issues, and they're going into legal caregivers' homes, and they're being let off their serious charges because they're telling on people that are legal. These patients have been arrested, seized, and forfeited by these multi-jurisdictional task forces, and we're protected from that.
Ms. Wilbur, we're at 2 minutes. Thank you for your testimony.
Thank
you
you.
all for joining us. I'm going to call 6 more people, and we're going to continue on.
Could I ask a question on 4834? The registry that it establishes and keeps records of medical marijuana patients, doctors, and...
I'm going to ask because you've had your time. If you stay, you can catch any... we all have to go to session, but my staff member will meet with you right afterwards, right behind me. You can do that, and then we can answer your question now or follow up with you. I'm going to call the next 6 people, and then we will adjourn while we attend session. We'll go at recess and not adjourn. You can watch session here in this room, 521, and also in 502 and 327. As exciting or unexciting as it may be, it will at least allow you to know when we're done and when we're on our way back. So with that, it's very difficult for me to predict, and I apologize. It's the nature of the beast. I'll step a little out and say it's probably about an hour and a half today, but it can be much shorter or it can go much longer. We'll start then. The next 6 would be Steve Sharp. Oh, did he? Oh, thanks. I'm sorry. Had you down twice. We had you down twice on the list. Tim Beck, Jay Van Dyke, Charles Kinzel. Did he go on? Oh, I'm sorry, we had you down as well. All right, Tim Beck, Dr. Robert Thompson, Charles Kinzel, Dennis Roet, or Riat, Dewey Thomas, and Pamela Thomas. Mr. Beck, if you'd like to begin for us.
Thank you very much. This is kind of interesting. I guess by way of introduction, I'm probably the person in Michigan most responsible for this law being passed and getting the funding for it and doing all the stuff leading up to it. And I want to mark an anniversary because, ironically, this March, 5 years ago, we were writing the law. Okay, and you are doing what we were hoping would be done. There was no sinister plan to legalize marijuana. We worked the best we could with models that we had, and so on and so forth. And I truly believe that unless the legislature weighs in, we got a problem. This law will never become legitimate in any way, shape, or form. It'll be up to judges. It'll be up to the Attorney General. It'll be up to people that don't have the best interest of patients in mind, and please weigh in on this. Now, as my specific comments about these bills, I say I defer to Cannabis Patients United, and that language that they submitted is perfectly acceptable to me. I think that would do the job. It would be fair all the way around, to all parties. Now, I want to specifically speak about the doctor-patient relationship. I think that needs to be codified into law, and I say that because marijuana, it's neither fish nor fowl. It's not something approved by the federal government or anything like that. And what I'm afraid of, here's this memo from Laura. You all saw that from Ray Ramsdale on the 13th of January. Now, it lists, good things here with respect to what doctors, what they should be doing. But then there's some other words in here. It says, have a bona fide patient relationship with the patient, have pre-existing ongoing relationship, and ensure the issuance of recommendations is not disproportionately large or even exclusive aspect of their practice. I don't know what that is. I call it a veiled threat. Okay, and I think the language that you've got written, it needs to be into the law. And I don't like the psychological thing. I think that's already been addressed. But I think it's absolutely imperative that you weigh in. I don't want that fox in the Attorney General's office watching the hen house, folks. Okay, and I don't want these judges and the kind of interpretation. So thank you very much for everything you've done. It's deeply appreciated. Actually, you're doing what we were hoping would be done later on when we wrote the basic law. Thank you, and God bless you.
Thank you. Sir?
My name is Dennis Riat.
Dennis, if you don't mind, there you go. You've got a good loud voice, but just in case.
My name is Dennis Riat, and I'm a patient and caregiver in the medical marijuana program. From all the testimony you've heard from everyone, I'm sure there's a lot of issues that everyone has with it and things that are wrong. I have to overlook it all because there's a very, very, very serious thing that we're all kind of evading here. And we just heard it. What if cannabis cures cancer? So all of this, all of the small little things that we all get involved in these rules and regulations and trying to keep it out, fighting between the different sides. And I heard sides. The first words from the Prosecuting Attorneys Association, I heard sides. And we're getting into sides. This is a human health issue. We need to embrace this and really look into it. We need to research. I am also a maker of cannabis oil. I have seen and I have been fascinated, and everyone with me, with the fantastic results that we get from it. I also acquired this, and I would like to present this to the committee, to the Judiciary Committee, as evidence. This is a what if cannabis cures cancer made by some very fantastic doctors that have been researching it long before I ever even knew it was possible. I make the oil, and my sister had a pituitary tumor. She became my patient. It's gone. You heard from Kirsch Avery. His is gone. And this is all, it just keeps going on. You people are being charged, and I hope that you can see through, and I think you can. You're intelligent people, and so am I. I hope that you look past all of the propaganda that's been going on. People's lives are at stake, and we have a cure for cancer. And I think it's fantastic. And you have to look at that. That's just, we have to be very, very cautious in dealing with this. And I leave this for evidence.
If you leave that for members, I will have that available in my office if you wish to see it. Thank you.
Thank you very much.
For that. Sir? Hi.
Hello, Dr. Robert Townsend, also known as Dr. Bob. I'm a medical marijuana certification physician, and you all have a 5-page document from me, a physician's response to House Bill 4851. It's the one with the moose with all the snow on it, okay? I had my UP clinics last weekend. As you may know, we fought over 20 inches of snow. We had blizzard conditions and whiteout conditions, over 20 hours of driving between 9 o'clock Friday night and 3 a.m. Monday morning. Had 4 clinics up there. Due to the new bona fide clinics, requirements from the medical board, there are very few opportunities, and they had to come when I came. You may not feel bad about me driving 20 hours through a whiteout. I would ask, however, you think about the patients that drove 6 hours after their 3rd laminectomy to come and present me with records that they could have easily have faxed my office. I might add, today it's 65 degrees in the UP and there's no more snow. Welcome to Michigan. All right. I find it ironic that one of the things that is required in the bona fide physician act is that a hands-on physical exam is required. And telemetry or telemedicine is specifically not, yet right across the hall in the Health Committee on House Bill 5421, they are demanding that health insurance companies pay for telemedicine services. There are 3 different types of medical office visits. Let's get you that mammogram, preventative. Let's find out what that lump is, diagnostic. Let's see what we're going to do about that adenocarcinoma of your breast, consultative. Medical marijuana certifications are dealing with patients with well-known and documented diagnoses. They've been going to the pain clinic for 2 years. They've got cancer. They've got Crohn's. This bill is treating them as if this is a diagnostic office visit where you're coming in and say, what's that lump? Well, I know what that lump is. It's adenocarcinoma. You're on your 4th round of chemotherapy, and you'd like to have something to get rid of your nausea. Okay. I wish that you would consider that, and you consider the people in the Western UP when you do look at some of these visits. Telemedicine is with us to stay, and I think that we should be looking into that for this. Thank you.
Thank you, Doctor.
May I add one last thing? In America, we get to defend ourselves in court. That includes the Section 8 defense.
Thank you. Sir?
You got a repairman here? Union, I hope. Ladies and gentlemen, I guess it's still morning. I may look like a picture of health, but I'm not. I have a degenerative back disease and acute arthritis in several places of my body. And do me and my wife look like criminals? Well, the state police say we do. We have a small farm that is highly isolated in the woods. In August, a helicopter flew over and saw what was suspected to be cannabis, which was legal. Instead of coming and knocking on our door, like the officer last week said that they would do, about 15 or 20 minutes later, 2 LawNet cars came down our driveway, busted through our secured gates and fence, which is highly electrified to keep, we really don't, no one even comes to our house because we're so isolated unless they call first. Even our meter readers don't even come to our house. We take our own readings and report to them. Then, like I said, they came through our electric fence. They pulled our plants out of the ground, threw them into the back of a pickup truck. Only then did the officer ask if I had a medical marijuana card. I provided it for him. I asked, why did you steal my plants? He said, case law, no roof. I asked, what case law? He wouldn't answer my question. Just kept saying, case law, case law. Then he drove off. 4 months later, we are arrested and facing a 4-year felony and a $20,000 fine.
Sir, we're at 2 minutes.
She can continue on with me.
That is fine. And we are going to wrap up right at 2 minutes because we're
Okay.
right up on top of session.
My name is Pamela Thomas. This is my husband Dewey, who just spoke. I was at the property when this happened, before my husband actually returned home. I provided my card and identification, and that we were caregivers as well, before the plants were confiscated. However, they still were confiscated. We, in our legal situation now, are extremely fearful that we will be denied the capability of using the defenses provided to us by this act. We were in compliance as to every aspect of the act, and here we are spending what should be our golden years, we're both in our 60s, battling the legal system for the first time in our lives. Now, that being said, I do have some comments on the actual bills. As far as the photo ID, I think it's a great idea. I also think it's a great idea that the capabilities of production and sharing photographs be shared with the information that's already in the Secretary of State's database. Every year now, when you get a license renewal, they send you the application with your last photo ID. So, you know, I really think it's nitpicking. If you call for a 2x2 inch photo, that's going to change the size of the cards. It should be transferred from the Secretary of State, if that's possible. And furthermore, 6 months for a recent photo. Law seems to feel that 4 years on a driver's license photo is adequate, so I think that is being nitpicked. I do also feel, as far as doctor-patient relationship, there's nothing in it that says or addresses the fact that patients who are on Social Security for medical disability should be automatically qualified.
Thank you for joining us. Folks, just for those of you that do intend to return, I will not start, just in case we go really fast, we will not start before 1, so you can grab lunch. I simply can't predict when we'll finish. I apologize for that, but we will return to this room no earlier than 1, and as soon as we're done with session this afternoon. Thank you. The committee stands at recess.